My name is Steve North, and I'm an Assistant Attorney General representing the Department of Ecology Water Resources program. I've been doing this work for 5 years now, and one thing I've learned in the 5 years I've done this is that water law is definitely, it's a tough area to understand. Even practicing water law every day of my career for the last 5 years, it's tough. So what I'm going to do in my presentation today is touch on some of the basics of water law, and also cover some of the seminal Supreme Court and Court of Appeal cases, as well as some current cases that are ongoing and should be of interest to you all. Hopefully towards the end we will have time for questions. As the standard disclaimer, I'm up here today in my personal capacity, not representing the formal views of the Department of Ecology or the Attorney General. I will be talking about just the basics of water law, and I think that probably a lot of this has been covered this morning, but it just never hurts to cover the basics enough. As we probably talked about this morning, Washington does follow the prior appropriation doctrine. And what that means is first in time, first in right. First to get their water right has priority over all other water rights. The doctrine of prior appropriation was codified in the 1917 Water Code, which is in the Revised Code of Washington, RCW 9003-010. And what it did is it established a system for adjudication of water rights, enforcement and regulation of water rights, a system for obtaining new water rights, and a system for transferring existing rights, which touches on the question we had before I got started today. Prior to 1917, and I'm not going to talk much about this today, but Washington had a mixed system of prior appropriation and riparian rights. Riparian doctrine is a doctrine that comes to us from the East Coast and actually from England, I believe, and it's a doctrine of fair use of the resource, and given the scarcity of the resource in the western United States, it became evident that the riparian doctrine was not suitable for Washington State. Probably most important for those of you who have clients who are owning water rights or purchasing water rights, the prior appropriation doctrine is a doctrine of use it or lose it. If you don't exercise the water right, you can lose the water right. We'll talk about that more in a moment. So the question is, who owns the water? Believe it or not, it's the public. Water is a public resource that's held in common for the public good. Public ownership of water is recognized in the state constitution and in statute. So how do you use the water right? What we're here to talk about today. If you want to use the water right, or use water of the state, you need to obtain a water right. Progressing logically here, what is a water right? There's no single definition in the water code. Nothing is outlined as to what exactly is a water right. And I think if you ask 20 different people, you'd probably get 20 different answers. What I'd tell you is that it requires application of water, the state's water, to beneficial use. Beneficial use is defined in statute as well as parts of the Constitution. It includes agriculture, irrigation, and stock watering, mining and manufacturing, which I believe is one of the beneficial uses recognized in the Constitution, power production, domestic and recreational uses, fish and wildlife maintenance and enhancement, preservation of environmental and aesthetic values, and all other uses that are compatible with the enjoyment of the public waters in the state. So as you can see, beneficial uses are broadly defined, and you can get a water right for just about any of these. In fact, all of them. Before water rights were established in the 1917 Water Code, we had a system of common law water rights. Water rights were established in the olden days, so to speak, essentially by posting notice of intent to use the water or beginning to divert the water at the resource. So you'd have somebody actually go out and post notice where they intended to use the water. And that, of course, demonstrated, not to be repetitive, an intent to appropriate the water. The next step, prior to the Water Code, was to develop the water right with reasonable diligence. The reason you had to develop with reasonable diligence was to demonstrate that you are actually serious about using the resource. A common tenet of Western water law is that speculation with this limited resource is disfavored. Continuing on, you had to put the water to beneficial use, of course, and that's because waste of water is disfavored. And waste would include using water far in excess of what a reasonable practice is for that particular use, or use of water for frivolous purposes. How are priority dates established? Again, it's a first in time, first in right concept with water rights. Priority dates were established prior to the Water Code under what is called the relation back doctrine. Priority date would relate back to the date when the appropriator initiated use of the resource. So in this instance, in these examples here, it would be when the appropriator either posted notice or actually began to use the resource. That would establish the priority date for the water right. Again, the priority date is very important because it establishes your water right as superior to all water rights junior to yours. Is everything okay here? Okay. All right. So we talked about how water rights were established prior to the Water Code. We're going to talk about a little bit now how water rights are established under the Water Code. There is, of course, an application process that's outlined in statute, RCW 9003-250 through subsection 370. First thing you do logically is you file an application for a permit. Since the 1917 Water Code, water use within the state of Washington, with the exception of exempt uses, which we'll talk about here in a bit, a water permit is required. And water permits can be obtained from the Department of Ecology, any regional office, and in fact, they may be available online. We might need to ask somebody from the Department of Ecology if that's true. What is included in an application? Several things are included in an application. They include the name of the individual, municipality, or corporation applying for a water right. What is the source of the water? What is the proposed use for the water? What would be the time of use? And for example, for irrigation water rights, they're seasonal. So you can identify on an application just what the time of use would be. Where is the water going to be put to beneficial use? And how long do you think it's going to take you to complete the diversion? These are some of the things that are required in statute on applications for water rights. Continuing on, certain types of water right applications have special requirements. If you're applying for an agricultural water right, you need to identify specifically the land to be irrigated, the amount of water needed, and it is identified in what's called acre feet, which I'm sure is a term that many of you are familiar with. And if you're not, we can talk about it more in a little bit when we get to questions. If you're applying for a community or multiple domestic water right, one of the things you need to put on your application is the proposed number of connections for your water right. And applications for power purposes, reservoirs, and mining purposes have additional unique requirements that are in the statute. Continuing on about the application process here, the application for a water right does require public notice. This is just like the common law. What you're doing is you're declaring your intent through an application and through public notice to actually appropriate and make use of the resource. The priority date also will relate back to the date of the original application. And if that's actually incorrect, I'd ask somebody from ecology to correct me, but I believe that's true. So that's the codification of the common law doctrine that we were just talking about. And applications are processed with a couple of limited exceptions on a first-come, first-served basis. So the sooner you get your application in line, the sooner it's going to be processed. Some of the exceptions include what's known as the cost reimbursement process. And if any of you all are working with clients through getting an application through the Department of Ecology, you probably are aware that getting an application for a new water right or even a change, the application lines are very backlogged. But they can be sped up, and one way to do that is through the cost reimbursement process. And the way that works, for example, is if you're fifth in line, you can actually pay to have the 4 people processed ahead of you to get to your application. Other applications include, it's the law, folks, that's what it is. Other exceptions would include significant environmental benefit, and those are all outlined in what's known as the Hillis Rule, which discusses how applications are processed. The state's analysis on an application is something I'm sure you touched on today. It's the 4-part test, which is outlined in RCW 9003-290. Under the four-part test, water must be available for appropriation, obviously. Water must be put to a beneficial use. The water right cannot impair existing water rights. And the water use must not be detrimental to the public interest. If the test is satisfied, then the Department of Ecology will issue the permit to develop the water right. The permit will state just how much water can be used and the purposes for the water use. So that raises a question, is a permit a water right? You probably hear the terms interchangeably, a water permit, a water right certificate. A permit provides the necessary authorization to develop a water right. So in my opinion, it is not a water right per se, but it can issue for less than the application applies for, or the applicant applies for, excuse me. And in any instance, it will never issue for more than can be applied to beneficial use. So if you come and apply for 10,000 acre-feet of water to irrigate an acre, you're obviously not going to get it. So we asked, is it a water right? No, but it is certainly the step towards getting a water right. You have to develop it, much like you did at common law. And this is a direct quotation from the statutes, RCW 9003-320, regarding development of water rights. Under this statute, actual construction work shall be commenced on any project for which a permit has been granted within such reasonable time as shall be prescribed by the department, and that shall thereafter be prosecuted with due diligence and completed within a time prescribed by the department. Again, what you see here is the anti-speculation doctrine that we talked about at common law codified into the water code. Because this is a limited resource, because there is a lot of competition for this resource when a permit issues, the idea is to make sure that you're serious about actually using the water and not tying up water that other people could beneficially use. Continuing on, extensions and cancellations of permits. Ecology may grant extensions to develop permits for good cause. Things happen, market conditions change, your project might bog down. So when that occurs, typically what happens is you go to the agency and get an extension to develop your permit. But if permits are not timely developed, Ecology may also cancel the permits. Here we get to the water right certificate. Under RCW 9003-330, a water right is considered perfected when the permit is fully developed. A perfected permit, in my opinion, is a water right. Upon perfection of the water right, that is, you have completed your appropriation, you have put water to beneficial use for the purposes for which you submitted an application, the water right or the water permit holder submits what's called a proof of appropriation to the Department of Ecology, which says, look guys, I'm done. Ecology will confirm the appropriation, and when that's done, a certificate of water right issues. That's what we're all looking for, is the certificate. Issuance of the certificate is the final step in developing a fully perfected and vested water right. As probably a lot of you know, there aren't many water rights for surface water anymore, but is the process the same for groundwater? The process is the same for groundwater, and this is also contained in the statutes. And in the interest of moving this along, I'll just let you all look that up if you need to. Is a water right a property right? I'm sure you also touched on this today. A fully perfected water right is a property right. And I heard Catherine talking about this just before I got started. Water rights are often considered usufructory water rights, which is a right to actually use the molecules of the water. Perfected water rights are also, again, considered appurtenant to the land upon which they are perfected. I touched on that before we got going today, which leads to the question, can they be transferred? And the question is absolutely yes. And the transfer statute for surface water is RCW 9003-380, which allows changes or transfers to perfected or fully developed surface water rights. If your water right is not developed, if you're still in the permit stage, and it is a surface water right, it cannot be transferred or changed. When an application for transfer is filed, Ecology will conduct an extent and validity analysis of the water right. We'll talk about that more here in a moment. And permissible changes to surface water rights include place of use, purpose of use, and the point of diversion. A change can be approved by the department, and the department will investigate a change to determine whether the change will cause detriment or injury to existing rights. That's also known as the impairment test. The idea with a change is to ensure the status quo for all junior and senior water rights within the system. So as long as you do not disturb that status quo or cause impairment to other water rights can be changed as outlined. Application to ecology and public notice are required for changes and transfers of surface water rights, but there is no public interest test for surface water transfers, and that'll make more sense when we talk about the case law here in a little bit. Let's talk a little bit about groundwater now. Under RCW 9044-100 subsection 2, which is a groundwater amendment or groundwater change statute, there are changes that are permissible to groundwater rights. This specific statute allows changes to the manner or place of use of unperfected groundwater rights. So unlike surface water rights, there are certain changes that you can make to groundwater rights that are in the permit stage or not yet fully developed. And manner of use is not the same as purpose of use. If you do want to change the purpose of use of a groundwater right, much like surface water rights, again, it does have to be a perfected or fully developed water right before it can be transferred or changed. And again, like surface water rights, the changes cannot impair existing water rights. There are a couple of other considerations with groundwater rights. One of them is that there cannot be an enlargement of the water right, and the changes must tap the same body of public groundwater. So essentially you're staying in the same aquifer. Continuing on with groundwater, there's some interesting and unique considerations as well. An application to ecology is required when adding new, additional, or replacement wells if the new wells change the location of the well or the manner or the place of use. But you don't always have to apply to ecology for a change if all you're doing is moving the location of your well. And that's contained in, I believe, RCW 9044-100 subsection 3. An application is not required to the Department of Ecology if the new well or wells are at the same location as the original well or wells. So when you apply for a groundwater right, sometimes you put down a well and you don't hit water. If you have a broadly described point of withdrawal for that well without coming to the department, you can actually resink your well. If a new well replaces the original well, the old well must be decommissioned. Talking a little bit more about changes and transfers. Changes that add additional uses or additional acreage are permitted so long as there's no increase in what's known as the annual consumptive quantity of the water right. The annual consumptive quantity of the water right, which is frequently referred to as the ACQ, is the actual amount of water diverted less return flows. To simplify that, what consumptive use is water that will be lost to the system forever. That's considered consumptive use. There will be no return flows and no return of that water to the system. So in particular circumstances, if you do want to add a purpose of use to your water right or spread to additional acreage with the same amount of water, you can do so without increasing the annual consumptive quantity. By way of illustration, to determine whether adding additional acreage or new purposes of use will increase the annual consumptive quantity, the actual test to determine whether something will increase the annual consumptive quantity is you average the highest 2 years within the last 5 years of continuous beneficial use of the water right. And that test is contained in 9003-381. So in this example, we have 5 years of consumptive figures, 87 and 83 being the highest. So you take those and your ACQ is 85. I see Fred nodding his head here, so my client thinks it's okay, so I'm going to move on. So, this is important. Can a water right be lost? Yes, they can be lost. We talked about use it or lose it when I first began my presentation today. There are actually two ways that a water right can be lost. One is through abandonment, and the other is through statutory relinquishment. Under abandonment, it's a common law test. This is not codified. There actually has to be an express intent to stop using a water right. After 20 years of non-use, the courts have established that there's a rebuttable presumption of abandonment of water rights, but it's a very hard presumption to rebut. Abandonment is essentially very difficult to prove. Not many people abandoning water rights these days given their value. Statutory relinquishment of a water right. If you have a water right holder who fails to use all or even a portion of a water right for 5 or more successive years, the water right can be lost either in its entirety or at least in part. And that's important to note because if somebody starts using less water than they're entitled to, absent an exemption from relinquishment, which we'll talk about in a minute, that portion of the water right can be lost. And that's one reason the prior appropriation doctrine is criticized, and people say that it doesn't work, is because it does not encourage efficient use of water. But that's the law we've got, folks. Is this better? Apologize, after a few minutes it starts to lean off. So going on with relinquishment, there are 20 specific exemptions to statutory relinquishment of water rights that are outlined in RCW 9014-140. Some of the common exemptions include, I'm not going to go through all of them, but I'm going to go through some of those that we frequently see in my shop because they're frequently subject to litigation, include what's known as the unavailability of water exemption to statutory relinquishment. And that one is called into play when non-use of the water right is attributable specifically to water not being available. Makes sense. You shouldn't be punished for not having your water right available to you. Municipal water rights are not subject to relinquishment, flat out exempt. Water rights that are claimed for what's known as a determined future development are exempt from relinquishment. And the way this one works is that if you go more than 5 years without using your water right, if you fix on a specific plan for the future development of that water right within 5 years of the last use of that water right, then you can claim that project for determined future development. What this is it's an exemption for big projects. The legislature, I believe, in this exemption has contemplated that sometimes it takes a while, once you have a water right, if you're going to change the use, to develop something that's big. And you shouldn't be punished if it's a multi-year project for not using the water right. And there are several cases that discuss this. We'll talk about them a little bit here at the end. It's an important exemption, and we're seeing it quite a bit these days. Another one that you might see is the operation of legal proceedings exemption from relinquishment. And when non-use of a water right is attributable to a legal proceeding, that non-use can also be excused. So, talk a little bit more about relinquishment here. In a case, the state actually bears the burden of proving the non-use of the water right. But if the state proves the non-use of the water right, the burden of proof will actually shift then to the water right holder to prove that one of those one or more, frequently sometimes many exemptions apply, but one or more of those exemptions do apply. So let's talk a little bit now about buying and selling property, moving this along. We talked about this earlier. Water rights do transfer with the land unless expressly reserved by the holder. So if you're out there buying a piece of property for a client and that property has a water right attached to it, unless the water right holder expressly reserves the water right is presumed to transfer with the land. When buying lands, if you do have concerns about the validity of the water right, and those are, I think, valid concerns and worth investigating, look at historic records of use. Look for any periods of non-use of that water right. Good places to look, first and foremost, check the title to make sure there actually is a water right. And certainly check with the county clerk. I don't know if the assessor would be helpful, but water rights are recorded. So the clerk would be a good place to go. And I think the best place to go would be to go to the Department of Ecology. The Department of Ecology has great records on just about all of its water rights that are available for the public to view. And they can be a wealth of information. So this is probably something that's of great interest. Do you always need a water right to use water? And the answer to that is obviously no. This is the exemption, RCW 9044-050. What does the exemption apply to? Stock watering, watering a lawn or non-commercial garden less than 1/2 acre, single or group domestic uses for less than 5,000 gallons per day, and industrial uses for less than 5,000 gallons per day. There are a couple of other exemptions in the law that pertain specifically to Whitman County, so I didn't include those today. So what happens when ecology makes a decision when somebody wants to change or transfer a water right, or ecology makes a decision on an application for a water right permit, and you're unhappy with the decision? Ecology's decisions granting or denying permits and their decisions on changes and transfers to water rights are appealable to the Pollution Control Hearings Board. And this is a body that sits in Lacey. It's a group of three environmental lawyers that have been appointed by the governor. At no time can more than 2 people from the same political party sit on the board, and cases are actually tried. We have trials before the Pollution Control Hearings Board, and from there they go on up through the courts. But that's how things get started. The Pollution Control Hearings Board does travel around the state for hearings. So let's talk a little bit about the Supreme Court decisions. I'm going to put this down just a moment to get my notes. There are a lot of decisions pertaining to water law that are in case law. And the reason is the reason we're here today. Again, this is not easy stuff, and it's frequently quite litigious stuff because the stakes are very high. I'm only going to hit some of the highlights, some of what I think are the pretty important cases. There's probably a lot of other important cases out there too that I'm not going to touch on today. But there is, in your materials that I passed out today, a water law primer that's on the Department of Ecology website, and it includes many of the significant decisions as well. If you do have questions about decisions that you're familiar with that I have not included in my presentation, feel free to ask questions, and if I can answer them, I will certainly do my best. One of the early decisions in water law, or certainly not one of the early ones, but one of the older ones in my materials today, is Stemple versus Department of Water Resources. Why is this decision included today? Well, the reason I included it is that the Stemple decision is important because unlike applications for land use permits or building permits, applications for water rights do not vest to the law at the time they are filed. So a water right permit, when it goes to the Department of Ecology, will be processed based upon the current law when the department gets around to processing it. That's what that decision stands for. The next decision, Okanagan Wilderness League versus the town of Twisp, is important for a couple of reasons. One of them is that even though a municipality cannot relinquish its water rights, it still can abandon them. And this is one of many cases where we see the Supreme Court stating that only the beneficially used portion of a water right is valid upon an application for change, or valid upon transfer. So again, when we're talking about changes and transfers, I mentioned that the Department of Ecology will conduct an extent and validity analysis, and the purpose of that is to determine whether any of the water right has relinquished or has been abandoned, and then only the beneficially used portion or only the valid portion of the water right can be transferred. Another important case is the Department of Ecology versus Theodoratus decision, which came down in 1998. In the Theodoratus decision, the Supreme Court affirmed Ecology's then new practice of requiring that a private developer establish actual beneficial use prior to obtaining a water right. Before the Theodoratus decision, Ecology issued permits for developers based upon what was known as the pumps and pipes theory, where Ecology would issue a certificate based upon how many connections the developer intended to build out. And I believe the posture of the case was the developer came in for an extension, had not even come close to fully developing out the water system, and Ecology issued the certificate based upon the actual beneficial use. And that was ultimately affirmed by the Supreme Court. This decision does not apply to municipalities, although there was some ambiguity after the decision came out as to whether it applied to municipalities. In 2003, the legislature passed a municipal water law clarifying that pumps and pipes certificates that were issued based upon system capacity prior to the Theodoratus decision are considered to be in good standing. That's currently in litigation. We'll talk about that here in a moment. This is the big one for the determined future development and the operation of legal proceedings exception to relinquishment. This is the R.D. Merrill versus Pollution Control Hearings Board decision. There are a number of reasons that this is important. One of them is that it talks about the fact that inchoate groundwater permits can be transferred as to point of withdrawal, place of use, and manner of use, but not as to purpose of use. So that confirms what we talked about when we talked about transfer of water rights. Some of those issues were litigated. And when I talk about an inchoate water right, that's a water right that's not fully perfected. That's a water right that is actually being developed. And again, that's groundwater. Another important component of the Merrill decision is that relinquishment exceptions are narrowly construed by the Supreme Court because the general rule in the state of Washington favors beneficial use of water rights. So when we look to the exceptions, or water right may not have been used, the courts are going to interpret those exceptions like determined future development or operation of legal proceedings narrowly. The Supreme Court stated in the R.D. Merrill decision that for the determined future development exception to excuse non-use of a water right, the water right holder must fix conclusively on a plan within 5 years of the last date of beneficial use of water rights. So that's again repeating what I discussed when we talked about relinquishment. That's where that came from, was the Supreme Court interpreting that exception to relinquishment. Another significant Supreme Court case is PUD number 1 of Ponderay County versus Ecology. This is frequently referred to as the Sullivan Creek decision. The reason this case is important is because in this case, the Supreme Court pronounced that the Department of Ecology does not have authority to consider the public interest test with surface water right transfers. There is no mention of the public interest test in RCW 9003-380, which is the surface water transfer statute. And so based upon that silence, years of practice of the Department of Ecology ceased. In the Ecology versus Campbell and Gwynn decision, which may be of interest up here, the Supreme Court held in a 5-4 decision that use of multiple exempt wells for a single development, where individual wells would pump less than 5,000 gallons per day, but collectively would pump more than 5,000 gallons per day, would require a water right. And that was a very controversial decision, as I'm sure many of you know. So let's talk now. Like I said, there are many more decisions, and they may be in the materials, and if you have any questions, let me know, but I want to keep this moving so there's time for questions. Talk about some of the Court of Appeals decisions. The Kim decision, which is not in my actual handout for the PowerPoint, but which I added thanks to a reminder from one of my colleagues, stands for the proposition that under the industrial exemption, a commercial nursery is an industry. In that case, the agency had taken enforcement against a commercial nursery that was using, I believe, 200 to 300 gallons per day, saying that it was not subject to the exemption. In that case, it was litigated to the Court of Appeals, where the nursery prevailed. And that was based actually upon the court's interpretation of what is an industry, and it concluded that the commercial nursery was an industry. So, another important decision at the Court of Appeals is the City of West Richland versus the Department of Ecology. And this is an important decision for a number of reasons, but one of the most important components of this case is that the Court of Appeals did confirm that you cannot change the purpose of use of an inchoate groundwater permit, and that the manner of use under RCW 9044-100, which we talked about before, is not the same thing as purpose of use. That was a question that was actually litigated in the case, and the court concluded that if the legislature intended to say purpose of use, they would have said purpose of use, and therefore manner of use is different. So I think the way we interpret manner of use in the groundwater code is that it is how you apply the water. The Motley decision, which came out last year, is also an important decision, and that's an important decision for a number of reasons, but mostly the decision stands for the proposition that if you're before the Pollution Control Hearings Board, that's where you need to put on your case. This is a case that was a relinquishment decision, went to the state superior court after there was a full hearing. And at the superior court, even though it was supposed to be record review, the judge actually ended up having pretty much a new trial, and that was ultimately reversed. So the time to actually put on your case is at the Pollution Control Hearings Board, because beyond there, it's record review. And there are a number of other reasons, again, that case is important. So what's going on in my shop right now? What are some of the cases to watch? One of the big ones that many of you may have heard about right now is Burlingame versus State of Washington in King County Superior Court. This is a challenge to the facial constitutionality of several provisions of the 2003 Municipal Water Law. We just also got sued on December 26th, believe it or not, by several Native American tribes that filed a similar lawsuit in King County Superior Court, also challenging the facial constitutionality of several provisions of the Municipal Water Law. These cases will likely ultimately be consolidated very soon. Before I move on to talk actually about the Cornelius decision, just some of the highlights of the lawsuit, and I can't talk about it too much because it's in litigation, but some of the things they challenge are the definition of a water right for municipal supply purposes, which was not in the law prior to 2003. One of the things the Municipal Water Law did that's being challenged is it resolved a prior inconsistency between water system service areas established by the Department of Health and Planning documents and the place of use set by the Department of Ecology in water rights certificates. There was frequently an inconsistency between what the water rights held by municipalities would say and the service area established by those folks that held the water rights. So the municipal law tried to resolve that inconsistency. Another thing is that it clarified that the service connection limit for a municipal water supplier that has a water system plan approved by the Department of Health takes precedent over any connection limit that may be found in water right documents held by with the Department of Ecology. So again, there was a conflict that frequently you would have a service area or water purveyor that could serve more than what the service connection limits said in the water right documents themselves. And what the municipal law did was say that that connection limit in Department of Ecology documents was not the guiding number. Let's see if there's anything else here. Okay, here's what was known as the Theodoratus fix. The municipal law clarified that municipal water rights documented by certificates specifying maximum quantities based upon capacity rather than actual beneficial use of water were deemed rights to be in good standing. Again, the Supreme Court's decision in Theodoratus cast doubt on the validity of those pumps and pipes certificate, and the legislature came back and said that those actually are rights in good standing. So that's in court right now. It should be a big lawsuit, and it should be a very interesting year. A case that's actually at the Pollution Control Hearings Board right now is Cornelius versus the Department of Ecology. And that's an appeal of ecology approval to 6 water rights held by Washington State University. And it raises many of the same issues of the municipal water law, but it raises them in what's called an as-applied context. The appellant in that case is saying that the municipal water law has affected me and my water rights, and so I'm challenging that, the decision that the agency made on those water rights. So, here we go. Again, the assertions are similar to those raised in the Burlingame decision. Another case that's going on right now is the Squaxin Island Tribe versus the Pollution Control Hearings Board et al., or Miller Land and Timber versus Pollution Control Hearings Board. The PCHB recently issued a decision in favor of the Squaxin Island Tribe vacating 2 permits that were issued to Miller Land and Timber for groundwater in a basin that was closed to further surface water appropriation. Miller had submitted an extensive mitigation package to offset any potential impacts to the closed surface water body, but the board based its decision on the uncertainty as to the effects of the proposed withdrawals on the closed stream. And what the case essentially became was a battle of the experts, and the board ultimately gave more credence to the tribe's expert. Miller and the tribe have both appealed that decision, and the appeals are currently in Thurston County Superior Court. And let's see if I have anything else here. The last one I'm going to talk about today, so we can get on to some questions, is the CPM Development Corporation and Icon Materials versus Ecology case, currently ongoing, and actually motions for summary judgment were recently filed. An application for a groundwater permit is seeking credit for recharge created by deforestation of the property. So the main issue in the case is whether removal of trees or other vegetation can be considered a resource management technique under 9044-055. And I hear some chuckles, But believe it or not, under RCW 9044-055, the Department of Ecology is supposed to consider resource management techniques when it issues permits. And the appellant in this case is arguing that this is a valid resource management technique. The PCHB in the past has issued decisions, and in fact there's a whole host of Western water law that says this can't be done. But this case has come after 9044-055 was adopted, so the appellant has potentially a decent argument. We'll see how the PCHB comes down on it, that this may be something that can be done. So that's what's out there right now. There's some more stuff out there right now. But again, in the interest of time, that's the end of my presentation. So I thank you for listening to me today. I hope it wasn't too repetitive. And I'll be happy to take any questions that folks might have.